Hey everyone, thanks for watching my presentation on tort liability in education, understanding risks and responsibilities. My name is Alex Garner, and let's go ahead and get started. So first, an introduction to tort liability. The definition of torts is a wrongful act or infringement of a right other than under contract, leading to civil legal liability. And that can be intentional or unintentional. There are intentional torts, negligence, and strict liability. Those are the three primary types. And the duty of care is a key proponent to tort liability, especially in educational situations. So, duty of care is the legal obligation to take reasonable care to avoid causing harm to others. Schools and personnel have a duty of care to protect students from foreseeable harm, and that is in various situations. So we'll explore that. All right, so let's get into intentional torts and the definition. So, intentional torts happen when someone acts with the intent to cause harm to someone else, and harm is caused. In our case, in the educational world, that can include student to student, teacher to student, um, administrator to student. Usually, our legal situations with torts will involve a student. Um, so, keeping that in mind. And harm is caused. Once again, harm can include physical injury, but it can also include damage to property or damage to somebody's dignity or their reputation. So, you see, we've got our guy with the physical injury and a little house with some damage to it to represent damaged property, and somebody with a little thumbs down that has probably some reputation damage. Next, getting into the types of intentional torts. So this is not an exhaustive list, but it is a list of types of torts that we see pretty often in the educational world. So firstly, we have battery. The definition of battery is an intentional act by a person causing bodily harm or offensive contact. So, an example to that would be, yes, a teacher physically striking a student for noncompliance or to get their attention. Of course, that's not the right thing to do. Next would be assault. A little bit different from battery, is an intentional act that causes reasonable apprehension of imminent harmful or offensive contact. So the example here would be that a teacher yells at a student and physically corners them in an intimidating way, causing the student to fear for their safety and anticipate physical harm being done to them. Next is false imprisonment. This is an act intending to confine someone to a bounded area without legal authority. Now, being a special education teacher, this is something that I learned about a lot in my master's program for that. Unfortunately, there have been situations in the past where students with disabilities are wrongfully restrained. When they are acting a certain way or disrupting instruction. And of course, that's not right. But another example would be a teacher locking a student in a closet as a form of punishment. Obviously, that is cruel and unusual and not something that we would like to see happen. And then we have defamation, which is making a false statement about someone to a third party that injures a person's reputation. So, an example here would be that a principal writes a negative and untrue letter of recommendation to a former employee that they may have had some disagreements with in the past. So, they came up with some lies about them to damage their employment opportunities in the future. Now getting into the second type of tort, this is negligence. And you see we've got a little guy crying and looks like a grown up walking away. To illustrate that, the definition of negligence is a tort that occurs when a person fails to exercise reasonable care and causes unintentional harm. So essentially, carelessness. So let's talk about the elements of negligence in education. So, firstly, Duty of care. Let's talk about that one more time. Schools have an obligation to protect students' well being. That is physical well being as well as mental and emotional as much as we can. Number two, we've got breach of duty. So, first thing about negligence is failure to meet the standard of care expected. So, failure to meet that duty of care, failure to protect a student's well being. Next is cause and fact. So the breach of duty of care would have to be the actual cause of harm or injury that happened to a student or someone else in the building. This is often referred to as the but for test. Number four, there's damages. So actual harm or loss occurred as a result of that negligence. And then proximate cause, lastly, where harm would have to be a reasonable, foreseeable consequence because of the actions of the defendant. So now that we know what negligence is, let's get into some negligence prevention strategies that school leaders can use to prevent it from ever happening on their campus or in their building. So, firstly, of course, we want to maintain proper student to teacher ratios for supervision. If we've got 45 kids in one class with one teacher, it is essentially impossible to ensure that all 45 of those students maintain their physical safety as well as their mental emotional safety. You can't catch everything that happens when you've got that many kids and only one person watching them. So, having a standard there would be pretty important to avoid injuries, as well as potential emotional harm when kids get into it with each other. Next, we have regularly inspect and maintain school facilities and equipment. Of course, we want to continue to do that to ensure safety, and that would prevent a negligence charge against a school or school district. Then there is developing and following safety protocols for all school activities. That goes without saying. Next, provide adequate training for staff in emergency situations. My school personally does this at faculty meetings, and we also have a drill each month. And we also have a safety team where teachers work with the assistant principal to maintain grounds and review how we do on drills and things of that nature. And then we also have ensuring proper documentation of incidents, as well as following up on those things to make sure that everyone's okay and understands what happened, and if there was any negligence on anybody's part, that that person understands what occurred and give them some strategies and support to ensure that that doesn't happen again. Next, we are going to get into strict liability. So, the definition of strict liability is a legal doctrine that holds a person or entity, in our case, that would usually be a school district or a state board of education, for the harm caused by their actions, regardless of whether they were negligent or intended to cause harm. This applies in situations where the activity is considered inherently dangerous. This is generally rare in educational settings, but it can apply in specific circumstances. Let's go over some examples of strict liability. So, example number one, talking about a science experiment. So, let's say a school is conducting a science experiment that involves the use of dangerous chemicals. And despite taking all the necessary safety precautions, a student gets injured, The school could be held liable for the student's injury under strict liability because the school chose to engage in an inherently dangerous activity, with the key word at the first part being dangerous chemicals, and the school chose to engage in that activity with that dangerous chemical. They assume the risk for any harm that occurred. Second example is talking about some playground equipment. So, a school purchases and installs a new piece of playground equipment. That equipment turns out to be defective, and a student is injured as a result of that defective equipment. Even if the school was not aware of the defect, they could be held liable for the injuries under strict product liability. That's why it's so important, even if it's a brand new thing, that we inspect all new equipment on our school campuses as school leaders to prevent injuries and things like that from happening. So, the rationale behind strict product liability is that the company that produces these products is actually in a better position to be held liable for when an injury or something happens as a result of their defective product, more so than the consumer, which would be a school district in this case, would be. Getting into some strict liability prevention, after reading through those examples, it's important to conduct regular safety audits of school premises and equipment. So at my school, my assistant principal has a routine procedure where he and one or two members of our school safety team will periodically check out various zones or quadrants of the school. We have two playgrounds. We also have a back pavilion and garden behind the school, as well as a school track, things of that nature. And then, of course, the inside of the building, the gym and the cafeteria and classrooms. They will go through and ensure that there are no hazardous situations or things set up that could cause an injury. We also want to implement proper storage and handling for procedures for hazardous chemicals or materials. In my school's case, at an elementary school, we don't have a lot of dangerous science experiment chemicals, but we do have chemicals that our custodians use, for example, to clean various parts of our building. So we want to ensure that those closets are locked and that students cannot access those throughout the day or at any point in time to avoid their being injured by them. Then we have maintaining detailed records of equipment maintenance and inspections. Once again, at my school, the safety team handles that. We also want to partner with reputable suppliers for school equipment and things of that nature. We want to ensure that we are getting our resources and materials for our students and faculty to use. We want to ensure that those companies are reputable and that they have a good reputation and high quality products before we invest in them. And then we also want to consider transferring risks through appropriate insurance coverage as a district, as a school. Right, so bringing it back to duty of care in schools. As we all know, schools have a special relationship with students and are legally required to provide a safe learning environment for them. When kids come to school and leave their families, we are responsible for keeping them safe. We serve as their guardian during that time. We serve in loco parentis, in place of the parent, until they go home. Our families trust us to protect them, and we definitely need to do that. So, duty of care includes firstly, safe premises. So we want to ensure that classrooms, hallways, playgrounds, and other areas are free from hazards that could cause injury to our students. Secondly, we have supervision. So that must be provided, of course, during all school activities, including classroom time, instruction, lunch, recess, and field trips. This also goes into having the appropriate ratio of teachers to students in a building. Thirdly, we have policies and procedures. Schools must implement and enforce policies related to physical safety, as well as things like reporting bullying and harassment, because we can have student to student cases of battery and assault, and we need to be able to address those appropriately. And then we have training. So we should also provide, as school leaders, ongoing training to staff on safety, risk management, and the best ways to go about doing that and protecting our students is the best that we can. Here are some general recommendations for avoiding torts in schools. Firstly, of course, we want to create a culture of safety and respect, and that comes down to firstly, of course, your principal and your assistant principal in your school. It also comes down to the teachers and students too, and families too. But the adults in the building really create that culture, and we have to prioritize safety and respect of all people in our building, and it starts with us. So that's super important. Secondly, we want to ensure adequate insurance coverage, as I've mentioned, for potential liabilities. It's also very important. Thirdly, we want to establish clear communication channels for reporting concerns. This is both for students and faculty to report their concerns to us as school leaders. That way, we can handle things systematically, respect people's privacy, and also get to them in a timely and effective manner. Fourth, we have implement proper hiring and vetting procedures for staff. We have got to be sure that we do this. And of course, there are legal parameters and background checks and things like that that happen to prevent unsafe adults from working in our schools. But we also need to do our own vetting and our own investigating to ensure that the people that want to work in our schools are a good fit and that they will create that culture of safety and respect that I've mentioned. Next, we have stay informed about changes, in education law and tort liability. And last, we have got to educate our students on safety protocols so that when and if something does happen, they know what to do. They don't panic. We don't go into chaos or mass hysteria. We know what to do. And the same thing, if something happens to them, if they are assaulted or if somebody, comes at them and hits them or whatever the case may be, they know who they need to talk to and they know how to get there and they do it immediately. Next, we have recommendations for avoiding torts and negligence in schools continued, specifically getting into risk management and its importance. It is an essential part of a school's planning for avoiding torts, from occurring on campus. So strategies that should be implemented in risk management plans include regular inspections. Again, super important. Really want to emphasize that. Conducting regular and thorough inspections of school buildings, grounds, and equipment to identify and address potential hazards in a timely manner. And making sure that our procedures that address all of these things are extremely clear, that there's no vague language, and that we're very specific as well. These are just a few other areas that we need to consider as school leaders when we think about procedures and policies and conversations that we need to be having with our faculty when it comes to tort liability and creating a safe campus for our students as well as our staff and faculty. So we need to also think about cyberbullying and school responsibility for that. What are the parameters surrounding that? Sports injuries and coach liability for our middle and high school students and faculty there. Food allergies and school cafeteria negligence is something to consider as well. Field trip accidents and duty of care there when we're not on campus. What does that look like? And also maintaining professional and safe teacher student relationships. All right. And lastly, to conclude, balancing education and risk management. So remember, over everything, prevention is always better than facing litigation or charges against you as a school leader or against your school district. Tort liability awareness is absolutely crucial for us in our educational institutions. And proactive risk management protects students, staff, and the institution that is your school campus and your district. Regular training and policy updates are essential, and balancing safety with educational goals is also super duper important. Here are my references. Thank you so much for watching.